Listen, my children, and you shall hear of the midnight ride of the new Paul Revere. She's with us tonight in the studio, bright, under the light of Take Back America. I'm William Wagener, your host, and with me is a new kind of Paul Revere, a former mortgage broker company owner. Her name is Valerie Lopez, and what she knows, you need to know. Welcome to the show, Valerie.
Thank you. Thank you for having me here.
Oh, thank you for doing what you do. First of all, let's tell people what your background is.
Sure, okay. Well, I've been in the mortgage banking industry since 1987, and I've worked with the best of the best, the pioneers of mortgage banking. Started off with Barron Financial Services, where I learned how to negotiate, sell, and transfer lawful mortgage loan packages. You need to form lawful mortgage loan packages prior to going to Wall Street and forming lawful mortgage-backed securities.
How long were you with Barron?
Oh, I was with Barron about 2 years. Past that, I worked for the Orange County Board of Supervisors. I negotiated various real estate transactions on behalf of the Board of Supervisors, such as a lot of real estate contracts dealing with the John Wayne Airport. I worked for the probation office, as well as formed a lot of contracts for the fire department, where they transferred from the cities to the county scenario. And following, I went back to the mortgage industry, and I ran the secondary marketing department for Bayside First Mortgage Corporation, and then moved on to purchase my own mortgage company in 1995, and I ran that until 2010, until I discovered that there were massive crimes that were going on.
Massive crimes going on after being 15 years with your own company. So you had about 25, 30 years in this business, and you got out because you recognized the lawyers for the banks were committing
felonies.
Felonies?
Felony crimes.
Felony crimes?
Yes.
And you decided you didn't want to be a part of it?
I couldn't be a part of it. I was raised by a law enforcement officer. He was an acclaimed criminal investigator, so in the depths of my soul, I absolutely cannot stand any type of criminal because they've always been a threat to me. My father was a single father, so I have this great hate for felons, unfortunately.
I understand. As well you should, as well most of us should. Well, people, I don't know if you grasp it, tonight on Take Back America, Valerie's going to help thousands, if not millions of you, start to understand why your mortgage broker, your banker, has probably committed perjury, right?
That's correct.
Fraud, right?
Illegalities.
Many, many illegalities, and the loan note you're paying on is probably among the bad paper, as they call it, that if you knew what she's going to tell you tonight, you could get rid of it, stop paying your mortgage, and have your home free and clear?
That's correct.
Do I understand you correct, Valerie?
Well, if a contract has been breached, especially with a felony, wouldn't you say that that would call for the fact that the homeowner didn't breach the contract first, right?
Yeah, if they took the documents he signed, which was what happened in the Pam Ragland's case. By the way, we just got word, I mean literally minutes before we went on air tonight, which is why we were a minute or two late. We got word that Pam Ragland's versus U.S. Bank was settled today, which would have been the second day of testimony. I was there at the first day, and I can tell you the judge did not like U.S. Bank. And the judge had seen some documents that had been filed, and he was ruling every objection was overruled, mostly in favor of Pamela Ragland's. And she is a single mom raising 2 kids, one with special needs. And I met her 13-year-old daughter. We have a little tape there, but we're not going to get to it right now. I just wanted to mention that because I don't want to interrupt the flow. But I was hoping Pam Ragland's would be the case where everything could be exposed, but she settled out of court. They must have offered her, I can't guess, but it was more than $1 million, because what they did in her case, what I heard with my ears and my eyes in Judge Franz E. Miller's courtroom after he denied my media request, which irritated me, so I can't show you the tape in the courtroom, but what I heard is that they had, or she had, Pamela, a single mom in the same house for 19 years, had remortgaged it, and she thought her remortgage note was going to be fixed. That's what drew her into getting involved with Downey Savings remortgaging, but they did a swap. They switched it on her, bait and switch it's called. Instead of getting a fixed rate, they socked her with an adjustable rate, which worked to her favor in the beginning because the rates went down a little bit. But what didn't work for her favor is that they committed felony perjury and fraud. And as I've said many times, there's no statute of limitations on something that was done fraudulently. It starts to run only when you discover the fraud, when you, the homeowner, discovers the fraud. Valerie's much more expert at that because she's been a mortgage broker. I only had a real estate salesman's license. She had a broker's license.
I was actually a mortgage banker. I ran a warehouse line.
She ran a warehouse, not your neighborhood corner guy. She packaged these things.
That's correct.
And she supervised them. With what, 25, 30 years experience?
That's correct.
You know fraud, right, Valerie? When you see fraud in documents, when they have a blank endorsement, what is that?
Well, first of all, they have us all hoodwinked. California Commercial Code 3-115 states that a blank line is not a blank endorsement. So let's get that clear right now. What that is, it's a negotiable instrument. It's a note with a yet unnamed payee. And that note will not be negotiable until that line is filled with the name on it. And that line will never be filled in, primarily because what these individuals did at the banking level is they chose not to abide by specific tasks that are required by the state of California prior to going to Wall Street to form mortgage-backed securities. Essentially, maybe what we should do is just discuss as far as how it should have happened.
Tell us. I think that's a good idea. Tell us how it should have happened.
Okay, well, I'm going to use an example here. First of all, after you sign your documents, you have, let's just say the main items are the deed of trust and also the paper note. We'll say that this is the note.
Okay, the note is the thing you signed promising to pay for what, 30 years or whatever?
That's correct. And we have the paper note, which we can fill and we can touch. But also included with this paper note is what's called a payment stream, a debt, an intangible obligation. And this is defined in a case. It's Henry Commercial Money Center, Inc., and it was a case that was viewed by Bankruptcy Appellate Panel of the Ninth Circuit.
Okay.
Okay, and they define an intangible obligation that we can't see here. But what I'm going to do is we're going to go ahead and use my necklace as the payment stream. This is the payment stream. We can't see it. It's intangible. Whoops. Oh, I guess that's not going to work, is it?
Well, let me unclip you for a minute.
Okay.
This is live, people. You're seeing it live. No editing here.
So essentially what we're going to do so that it's a little bit more concrete so people can see it. This is your payment stream. This is your promise to pay.
Your promise to pay. This is your
debt.
Your debt.
Okay.
And it's put in the note.
And it's a part of the note. Okay. So you sign your paper note. And we have also the deed of trust. So after
we'll label this note. Okay, this is the note. Your promise to pay. The stream is inside, which is here represented by her necklace. Okay, that's the note you've signed.
That's correct. So after you sign your note, whoops, it fell out.
Does, doesn't it? In reality, it has a way of getting out of the note.
You're right, yeah. So essentially, your note here is evidences the debt, which is inside of here. They're actually bound together. They're tangible. You can feel it. So essentially, once you go ahead and sign your note, let's just say I was presented with this as a mortgage banker, I would record the deed of trust and the note is still attached to the income stream or the debt, and I have perfected the security as far as the note and the deed of trust together. So essentially, what I need to do then is if I have a subsequent buyer who wants to buy this package, and this loan is one of many, what I would normally do is I would go ahead and make sure that these loan packages meet all the underwriting guidelines and are perfected. Everything meets. There's
Okay.
nothing is going to be defective in these people paying this obligation. So the next buyer would go ahead and review everything, and they would go and say, you know, Valerie, I like everything. You need to go ahead and record the assignment of deed of trust, which memorializes this sale, where everything, the tangible document is still together. And we look at the law, which is California Commercial Code 9109, which requires this, as well as California Government Code 272881. Now, a lot of attorneys will hoodwink us all and say, oh, it doesn't have to be done. Yes, it does. Those laws that I just informed you of is what requires this assignment of deed of trust. It's mandatory. And it's mandatory prior to going to the Wall Street door, okay, to form your mortgage-backed securities. So essentially, you have perfected the title. So once I have recorded my assignment of deed of trust, which memorializes a true sale.
And that's recorded in the county courthouse, right?
In the county records. The
Not
county,
just some bank's library. Not
No.
some bank's library, not the lawyer's library. It's recorded in the county courthouse.
You're talking about the mortgage electronic services? Yes. No, that's not considered. They want it in the states want it recorded in the state records, the public land records. So anybody can go and see who actually owns this lawful mortgage loan package.
Got it.
Okay? So if there's a subsequent buyer, they would do the same thing. They would hook both these together, ship them out so they can review the investments.
Goes to the next. Say, I'm the buying next person. I review it. Okay.
Everything's still together, right?
Yeah, it's still together.
Okay. And then once you say, I love it, I want it, record the assignment of deed of trust so we can meet the state requirements.
So I go to the county courthouse and I get it recorded?
No, actually, say like I'm selling it to you. I would record the assignment of deed of trust saying, I am going to be releasing this lawful mortgage loan package over to you, William Wagener.
To William Wagener, okay.
Okay.
I like that.
All
and do
right.
you have to pay the county recorder something for that?
Yes, you do. You absolutely have
And
to
are
record
those fees
that.
really tiny, like pennies and nickels, or are they
The recording
couple
fees usually
$100?
it's about $60, $60 to
$60,
$100. Yeah,
okay.
$60. And so, so you've perfected. Then I show you the recording numbers. Then you say, okay, great, thank you for recording it so that we meet the state requirements. Then you forward me funds then for that
I
package.
send you money.
That's correct. It's a legal and lawful mortgage
Okay.
transaction. We have negotiated, we have transferred, and we have sold.
Okay.
Okay?
And it's recorded in that county courthouse.
Correct. And this will continue all the way up to the person that's going to be forming a mortgage-backed securities.
So I hold this in my portfolio for a while, and supposing I decide I want to sell it to Randy. And Randy says, sure. You made a couple of months money off of that, and it looks good. And it looks like the value may go up. It might even be more secure. He wants to buy it. So now I have to endorse the note.
Endorse it. You got to keep that chain of title must
So
be
I
there.
have to flip it over, and even though you had signed, now I have to sign on that note.
So we maintain that chain of title.
Chain of title
The chain of title must always be maintained.
with the note. So then I have to then take the responsibility to go to the county recorder, record it again, showing I have assigned the deed of trust
That's correct.
to Randy,
To memorialize a true sale,
to a true sale.
which
Now,
meets the state's requirements.
Randy's got it, and he can then, if he wants to, put it with some others and sell it to Wall Street to make a security that gets bundled and sold.
Well,
Do I understand this right?
Well, as long as we have always maintained all the way to the last buyer who's going to be forming mortgage-backed securities, then you can go to Wall Street to form mortgage-backed securities. Okay, so maybe we should do now what they're actually doing now.
Okay. Now that's how it should work.
That's how we have to maintain that chain of title.
Chain
it's
of title.
Mandatory.
Okay, now what is happening that made you quit the industry and get out of it?
Well, what happened is that my business was really harmed by the slow economy, and so I had to reorganize my debt. So I thought it was the right thing to do is to file what's called the Bankruptcy 11 reorganization. So while I was in the bankruptcy court, a company called Pike Duncan decided to go ahead and lift a sale on one of my homes. And I thought, what are you doing? And then I was watching the paperwork that they were filing in the bankruptcy court too. And I was even further just so dismayed because it was all criminal documentation.
Criminal?
Criminal.
Pike Duncan was filing criminal documents.
Yes, they were.
Were they forged signatures on those documents? Or fraudulent statements?
I have reason to believe that there was a material alteration on the paper note. The reason being is I spoke with some employees who were employed by the original lender, and I asked her, did you assign this to Wells Fargo? And she said, no, I didn't. That's not my writing.
She said it's not her writing?
Correct.
This is in Orange County.
This is Orange County.
Orange County, California. It reminds me of Damon Dunn, who had forged signatures to get on the ballot for Secretary of State as a Republican. And we caught him. And Orange County Register did not, or not the Register, not the newspaper, Orange County Recorder, the election official did not want to talk about it. And I like, what do you mean? I just give you evidence and you don't want to see the evidence. I got a video on YouTube.
Interesting.
I introduced this elderly guy who's an inventor, has 80-some patents. And I have him on video saying, that's not my signature. I wasn't even in town on that date.
Wow.
I wasn't even in California. I couldn't have signed it. Orange County officials did not want to know. They didn't want to know. This guy was going on the ballot in the Republican primary with forged signatures. And he didn't have enough. If you take the forged signatures away, he didn't have enough to be on the ballot.
Interesting.
But that's another story. So we're talking about the same county who's losing recording fees because they don't record it. And explain.
Well, let me go ahead and tell you what some additional items that occurred also that just kind of really just blew my mind, actually. One of the other items that I noticed as well is that they had an assignment of deed of trust. And I'm thinking, wait a second. I have a document here saying that Freddie Mac was the last known owner who bought the payment stream. And the reason why I know that is because I don't see Freddie Mac in any of the public records. So there's a break in chain of title, and Wells Fargo is claiming to own this loan package. There's a break in chain of title here.
So if there's a break in chain of title, the whole document package is
suspect of a felony of unsecured debt being sold to Wall Street because they did not abide by the state laws concerning the actual paper processing of these paper documents, the tangible mortgage loan package. So,
which means the homeowner that doesn't know who he's sending it off because they keep changing and they get a notice, oh, don't send your payment to Wells Fargo, now send it to B of A or some other bank. And they keep, the homeowner is paying out a loan that is riffed with fraud?
That may have a breached contract, that's correct.
And if it breached a contract, what does that mean to the homeowner?
Well, I mean, in the case
the guy living in the house.
Right. In the case that there is a breached contract, especially when there's a felony involved, essentially what that means is that the debt, so what, you know, maybe we should, let me just step back, if you don't mind, to my case just for just a second here so I can just tell you a little bit more because it gets very interesting. So remember that assignment of deed of trust I was telling you that memorializes a true sale?
Yes. Okay,
so I had a document showing that Freddie Mac had purchased something, but Freddie Mac wasn't in the public records at all. Yet a employee of Wells Fargo was executing an assignment of deed of trust that was prepared by Pike Duncan, the attorneys, and it was a GN mortgage assigning to Wells Fargo Bank, the servicer. okay?
Wow.
And the signer was China Brown, who is actually, in reality, she's not an employee of GM Mortgage. She is a loan clerk for Wells Fargo, the servicer.
That doesn't smell right.
No, it doesn't.
It doesn't pass the sniff test.
And actually, the first hearing that we had, I really did very well. The judge required that China Brown come into the court to explain exactly what were you selling to your employer with an assignment of deed of trust. If Freddie Mac owns the debt or the payment stream, tell us, what were you selling and what were you doing posing as an employee of the defunct company, GM Mortgage, LLC? So we were set to be heard on April 8th of 2011, and what essentially happened is an attorney for Pike Duncan with unclean hands, Todd Guerin, called me up and pulled out his violin saying, I need a continuance because I need to prepare China Brown. Well, I was a fool, very naive, and at the next hearing, the judge and...
You thought attorneys were honest?
I did.
Oh,
I
no!
I thought judges were honest too. I really did. I was really in for a rude awakening.
Oh my word! You trusted the guy, and what he pulled a fast one on you. Let me tell you.
He did, but his Pike Duncan has a history of having unclean hands. So essentially, what happened is at the next hearing, Todd Guerin and Judge Kwan, they were like Michael Jordan and what's his name, Magic Johnson. Whew, they were really good. They were really good. I couldn't catch that ball if I wanted to. They wanted my house, and they were going to get it.
And the judge did a 180.
He did a 180.
Sounds like Judge Carter in Orange County Federal Court, Ronald Reagan, who said the issue with Obama's birth certificate is going to be heard by a federal jury. And then they gave him a clerk that used to work for Obama's former law firm? How does that happen? The judge in Orange County gets a clerk from a law firm in the East Coast, suddenly becomes his personal clerk, and he does a 180 and says, I'm going to dismiss this.
Oh, sounds very familiar.
Yeah.
I mean, very familiar.
We need a militia. We need grand jury, common law, grand jury indictments.
That we have it. Our founding fathers gave it to us, but it's up to us
to activate
to use the tools, learn it, and use it. There's a great website called www.1215.org, and if you start where it says start, skip all the videos and just spend a day and review it. By one day, you'll understand how to execute a Article 3 court, common law court, so that we can go ahead and get due process as American citizens.
Give me that again. What's it? W what?
It's www.
Yes.
.1215.
1215.org.
.org.
Magna Carta time.
Magna Carta time. That's right.
We'll have to look that up, people.
Yes. So essentially, what happened, there was like about, I want to say like 7 hearings or makeshift hearings. And one of the hearings, I brought the proof. Also, by this time, I had been trained by Lynn Simoniak. You know who Lynn Simoniak is,
No,
right?
I don't. I'm sure the public doesn't know. Who's Lynn Simoniak?
Well, Lynn Simoniak she was actually featured on CBS News on 60 Minutes. And she exposed the fraudulent documents that were used by the loan servicers to seize properties unlawfully in the United States.
Wow.
Thank you.
Wow. Are you hearing this, people? Are you getting this? Are you getting this? You ought to pay attention. She's going to teach you things that you can do. And by the way, that first hearing, she didn't have an attorney. She went in pro per up against these big-time. Of course, she did have 20-some plus years of experience in the mortgage business, but that's why she's here, to help you. Even if you've been kicked out of your house already, you may be able to sue and win and collect, as Mary McCullough did up in Montana or Wyoming. Montana. She won $1 million plus, I think, $5 million in punitive damages for the illegal criminal acts done by the bank. And I just got the word, as I told you, Pamela Ragland versus U.S. Bank. I just got word as we came on the air, they have decided to settle with her. And they only had 1 day of trial, and I was in there watching. very close. I got to say, I got one question I asked the U.S. Bank attorney that did most of the talking. I don't know who did today, but when I was there yesterday, a guy named Michael Stewart was doing the talking. And when he went to the elevator during the lunch break, I said, "Can I ask you a question?" He said, "Probably not." I said, "Well, I want to ask you anyway." And says, did Downey Savings and Loan, before or after you acquired it, did anybody take this note or any copies of the note or multiple copies and go to the federal discount window and cash it? What do you think his answer was?
Well, I'm sure he denied it.
He said, no comment. No comment. And I wonder if he worried and decided, if they discover what we've done and that we've duplicated the note 5, 10, 20 times, sold it that many times, and all the new buyers went and packaged it. That's 20 felonies. A whole lot of their friends are involved in. I wonder if that was just rumbling around in his head as he got in the elevator, because he said no comment, which is what I expected. But Pamela nailed him, and I hope she got at least $2 million.
I hope so too. She's worked so hard. She's
worked hard, and her lawyer's going to get a big chunk, and some other bills she's got to pay off. I think if she got $2 million, she'd probably have $800,000 left, and then she's got to pay taxes.
Right.
You've got to pay taxes on it. It's not a windfall. So, for you, Pamela Ragland, I'm sorry I won't get to see the end of this trial, because now it's going to be settled out of court. But anyway, back to where you were.
Well, I wanted to just say a few more things regarding what was going on in court, just so that people can clearly understand exactly what is going on in the courts. So essentially what I did is I hired Lynn Zamoniak, not only to train me, because I wanted to learn exactly how is it that she won $9.2 billion for the United States. She had filed a lawsuit which pretty much educated the crimes that were going on in our country regarding the unlawful foreclosures.
She laid it out in the lawsuit, so anybody who read the lawsuit would then understand the crimes that the bankers and their attorneys have committed.
That's correct. It was such a great lawsuit that the United States of America joined her.
The United States of America?
The United States of America
joined her.
Yes, it was 2012, and it was United States of America and Lynn Zamoniak versus Bank of America ETL, which means others, which would be all the other large banks, Wells Fargo, JP Morgan, Chase, etc. Correct.
Wow.
Yes. Okay.
Wow.
So essentially, I hired Lynn to help me. So she won $92 billion for the United States of America. She was my expert witness in my case. She did an affidavit for Judge Kwan, and essentially she just pretty much point blank said that the documents in Valerie's case are criminal.
But you didn't create them. The bankers' attorneys created them, right?
Right, Pike Duncan did. It said clearly on the top, prepared by Pike Duncan. So Pike Duncan
But I mean, we got to make that clear to the viewers, because when you say my papers were criminal, it sounds like you created criminal papers.
Correct.
So we want to be clear.
The assignment of deed of trust that was brought into the court to show that they had standing to steal my home, it was criminal.
It was bogus.
It was bogus.
And they were presenting it as legitimate and true and accurate, and now we can take her property from her.
And then in addition, what I did is I brought a document that shows, well, here's a letter that shows that Freddie Mac was the last known owner. So how is it that you are claiming to be the beneficiary in your proof of claim? This is proof that they have committed perjury. And the judge was, well, what we'll do here is we're going to allow them to do a redo brief. And well, you should have used Enri Gomez and also Enri Ville, or Enri Gomez versus Countrywide, and also Enri Ville. So he gave them the case law to use against me. It was just absolutely incredible.
And aren't judges supposed to be neutral referees?
They're supposed to be magistrate judges. You're absolutely correct. They're not supposed to be tribunal, which means essentially that we make up the laws, we the people. They're just there to go ahead and enforce the laws.
When he
So-
helps one side openly, that blatantly, it sounds like somebody slipped him some cash in the back pocket before.
The way he was acting like Magic Johnson, and
Yeah.
yeah, let's keep that ball away from her. Let's grab that house. But anyway, so essentially, that is what was going on in the court. But Lynn Zimoniak, she was my expert witness, and she was prohibited from coming to the courtroom to set up offense. Yes.
After winning $9 billion?
$9.2 billion, yeah. She was prohibited from coming into the case. In addition, I was prohibited from quoting, citing case law to protect myself as offense. He just refused to allow me to say anything. He refused to allow me to bring in the lady that confirmed that she never assigned it to Wells Fargo. And also the attorney, this is what's really killer. The attorney admitted that they were just the servicer. And there is a federal statute that says that servicers cannot be the ones that are initiating any kind of foreclosure whatsoever.
And that's the 9109 law?
Oh gosh, let's see if I can find it here for you.
Are we ready to see Pam Raglan? Let's take a look at Pam Raglan, who just forced U.S. Bank, and we taped this just Wednesday, just 2 days ago.
Here we go.
Let's take a look at this while Valerie Lopez finds this document. Let's take a look. There she is. The audio is going to be a little jumpy here. Something went wrong with the audio, but there's Pamela in front of a U.S. Bank. Do you ever see those buildings that say U.S. Bank? Can you bring her audio up? It's going to be choppy
Also
anyway.
FCI and DSL, which are the trustee and the lender services people.
And do I have your unconditional permission to publish this on my television show, On Second Thought and Take Back America, and on YouTube and internet?
Yes, you do.
Her case actually started back in 2008. What happened that you first found something was wrong, Pamela?
Well, actually, it goes all the way back to 2002. And what happened was I got a refi on my house thinking that I was changing my loan from a variable rate loan to a fixed rate loan. Except for there was a question about some fees. And I wanted to use my own notary